Hi, everybody. Just letting everybody get logged on. You guys can holler at me if you need something, but we're just going to let everybody get logged on. There's a couple of things I want to talk about today because I had a question about it earlier. Just so everybody's aware, I will be at AGLA live and direct in Koreatown tomorrow for a lunch and learn. So if you're available tomorrow and want to come have lunch with me, I'd love to see you at AGLA headquarters in Koreatown. So would love to see you there. Also, I'm going to put a raffle item up on Widget's Way website. It's only for my Widget's Way members, so only for you guys for this month. I'm going to raffle off a purse. It's just randomly going to go out to one of our Widget's Way members that wants to get in the raffle for the purse. I try to give a lot of things away in November, so we may have a couple more giveaways on the website in the month of November. Happens to be my birthday month, so hey, got to give things away. So I had a question today about reserve accounts and what they're used for and how it helps us. So if we're managing property for profit, we want to make sure that we have a reserve account. Patty, what's a reserve account? Well, Sam needs a new garbage disposal. Sorry, I'm still letting people in. Sam might need a new garbage disposal, and in order to help facilitate the expenses for that garbage disposal, when we manage property for profit, we hold funds in a reserve account. Some of us ask for $200 to hold in the reserve account. Some of us ask for $5. A lot of people want to know, what is that, Patty? What is a reserve account? A reserve account is so that we as property managers can still function and do business based on repairs at the property without having to dig into our own pocket. Oh, so what the majority of us do is we have a reserve amount so that when a landlord signs up with us, we hold the security deposit, we hold $500 in their reserves for repairs and so forth. And as we do a repair, we replenish the money out of the rents collected. That way, the deductions for the repairs are coming out of their rent monies. And we can talk more in detail on how to make that happen for you to make it more profitable and less stressful for you in the long run. A couple more things I want to talk about today, obviously, are the new rules that are hitting us and the new laws, making sure everyone is aware of them. There are two that are really affecting us. I don't know what just happened. Hang on. Where did I go? Do you guys still have me? There I am. Okay, I'm here. It's preparing a whiteboard experience, and I'm not trying to whiteboard nothing. I don't know, I didn't touch it. All right, so I want to talk about the new laws that are coming at us, okay? A lot of people are panicking over them. There's only two of them that are really you need to pay attention to, okay? One of them, first come, first serve. When you're running your applicants, you're going to have to take them first come, first serve. It's been a better business practice of fair housing for over 20 years. Now it's the law. You got to take them first come, first serve. What happens if I don't take them first come, first serve, Patty? You can't charge them a screening fee. That's how that's going to work. So you're not going to be able to charge a screening fee if you don't take them first come, first serve. We've been taking them first come, first serve for decades because it's much easier to deny them if they don't meet your minimum criteria. Not meeting the minimum criteria is a problem. It's a reason for denial unless they're on Section 8. Okay, so keep that in mind. Okay, we have to take them first come, first serve. There's no longer we're going to pick the best out of the bunch. It's just a bad business practice. It exposes you to way too much potential discriminatory issues. Oh, we don't want to play with that. The other one that's hitting us should be happening already. It's a great business practice. You know, we take pictures of the property when the tenants move in. We take pictures of the property when the tenants move out. We take pictures of the repairs when they're being done. That is the new process and procedure. In order for you to deduct from the security deposit, you're going to have photo documentation. That is in effect now. It'll probably be implemented with force starting January 1st. Take photos, okay? You're going to need them. Now it's not, it'll help you plead your case. Now it's required. But Patty, I don't have in move-in photos. Then you're not charging them anything when you move out. Good luck. They're going to make it more and more difficult for us to do business as there are more and more tenants and less landlords.
Patty,
All right.
what
Yes.
about the things that cannot be seen, like smoke, nicotine odors and stuff like that?
Different set of facts, but you have to have photos at move in, at move out, and of the repairs in order to deduct it from the security deposit. If you don't have photos, you can't deduct it, okay? Patty, can you remind me of the names of the two laws again? They're Assembly bills and Senate bills, and I'm going to go on a mission and find them for you right now because I like you very much, Julia. Hang on. Hang on. They're loading on my phone. Just bear with me. I don't have them memorized yet. Oh, no, that's a proposition. Just so everybody knows, we won Prop 33 in the election yesterday.
Yay.
Hey, yay. Applicant screening fees. Assembly Bill 2493. This bill would allow a landlord to charge an application screening fee only if a landlord considers and approves the applicants in the order the applications are received. They may not charge a fee unless the applicant is considered and not charge a screening fee when no unit is available for rent. And it also creates the obligation to furnish a copy of the credit screening report within 7 to 10 days. So it's no longer upon request, you're gonna have to supply them with it. And then cleaning fees is Assembly Bill 2801. This would limit landlords' claims for deductions against tenant security deposits to normal wear and tear and requires the taking of photographs upon commencement of the tenancy and the end of tenancy of all items requiring repair and cleaning. So there's your two little tickets that aren't going to be pretty ones. Okay. Everybody hear all that? Yay on 33. I was ecstatic. And I did post on Facebook. I'm in LA today and tomorrow. So I'm really hoping that we don't have any protests because of the political stuff going on. I don't have time for it in my schedule. So I'm hoping and praying that it stays quiet. I had a kitchen fire in a rental in Kern County. Apparently someone left something on or in the oven. The fire report was vague and basically said oven fire. Here's my question. How do I ask the tenant for my $2,500 deductible? I know they're on a fixed income and say they don't have it. I don't really want to give them a 3-year payment plan, but I may need to. What if they refuse to pay? If they refuse to pay, you can evict them. If they had insurance, you could ask their insurance company to pay the tenant, the owner's deductible due to the tenant's negligence. You could make a payment plan for them. You could sue them in small claims and get a money judgment against them and garnish their wages while they're still in possession. You could, I'm giving you options. No wages, no income. Make a payment plan with them even if you don't want to, honey. Doesn't sound like you can get blood out of a turnip. And that's me just trying to talk to you. Total turnips, rents way under market. So you're gonna have to let them know because of the fire, you can't continue with this relationship. That not only are you out $2,500, I think I remember this. They also have an adult son who I think did the fire. Unfortunately, you have unauthorized occupants, and this fire was deemed to be at your fault. I wasn't cooking food in your oven at the time, you were. Therefore, it is deemed your fault. My expenses are $2,500. Are we going to work out a payment plan for that? How did you wish to pay for that? Start talking. Start asking them. Because you could get a judgment against them and then file small claims and try to go that route, but you can't get blood out of a turnip. I don't want you to spend a whole bunch of money just to prove you're right. So ask them what they want to do. How do you evict? You asked me a question, I'm processing it, Val. Here, I'm just gonna say it, okay? Val, it doesn't matter how you get them out. You could go off unauthorized occupants, unauthorized pets, failure to provide insurance. You got plenty of teeth, okay? If they're on a month-to-month and the property hasn't been fixed by the insurance company yet, you could deem it uninhabitable and force them to vacate and then evict them if they don't. There's quite a few options you have. Here's what I'm going to say to you. It's Kern County. It's not LA County. They're not crazy yet. And it's in a county that doesn't run along the coast. So the chance of that going through jury trial and all that other stuff gets a much narrower window than the rest of us are faced with. So don't fear the eviction, Val, just start the process. Evictions in Kern County are not like LA County or Orange County or San Diego County for that matter. They run more like Riverside County, San Bernardino County, Kern County, Inyo County, still very pro landlord. Start the process. Has to do with where you are, not what you're doing. Hope that makes sense.
I have a question for you.
Sure.
The same tenant that I keep telling you, I keep running interference with constantly, got something in the mail yesterday coming from the County of Los Angeles Department of Public Health. Again, at least 3 times a year, she either is reporting me to LAHD, which they wound up closing the case out. She's gone to, like I said, Better Business Bureau, and now this time it's the public health. And what it says is that the alleged violation by the owner is the bathtub drains slowly and the kitchen pipes are cracked. How would she know any kitchen? I just did what, $9,000 worth of work in, I think it was June or July, of the plumbing in her unit only. There's no cracked pipes because they put brand new pipes. I watched them. I have it on video. So there aren't any cracked pipes. And as far as water going out, everything was running fine in June because I had that done as well. And if anything, it's probably maybe hair in the drain. I don't know. But what I wanted to know, if I keep on, and I consider this harassment, I would like for you to give me a suggestion on how to handle these harassment cases, because this is nothing but harassment over and over, 4 times a year. And she has the newest unit in the building. So tell me how to handle that, please. And obviously it's LA and it's Larso and etc.
There is no harassment against a landlord. There's only harassment against a tenant. She's intentionally doing what she's doing on purpose. I had a tenant that called fair housing every 5 months. Do you know why? Because I couldn't touch them for 6. They know the system. They're using it to their advantage. They are working you. So how would I get rid of that tenant? Cash for keys or sell the building. I'm too old to be challenged that way anymore. And it's exactly what's going on. They're challenging you in every way, shape, form that there is. Like I was saying, you can't touch a tenant that has a fair housing claim for how long? 180 days. That's right, 6 months. So if they call fair housing again and file another claim in 5 months, does that mean their 6 months starts over again? Will a litigious tenant do that to their advantage?
Patty, what do you mean you can't touch them though?
If you have a fair housing violation and fair housing says, you can't do that, you need to repeal this notice, you're not allowed to do that, you violated fair housing. You can't tell that tenant that they have to move out for 6 months, 180 days, or it's retaliatory. Make sense?
Yes, thank you. Even if they don't, so in that 6 months, they decide not to pay rent, then.
Different set of facts. Non-payment of rent is a material breach. You
Okay.
saying you want them to move out is not gonna fly.
Got
Okay?
it, thanks.
So yes, there are tenants out there that are very, very savvy. I'm getting loved on by a kitty cat. It's awesome. I'm sorry. It's like a squirrel, you know? I'm getting good loves from a kitty, purrs and everything. It's awesome. Sorry, I'm at one of Widget's Way members' home studios today, where I can come and help you in person if you need it.
Okay.
I see another question. How can I modify a rental agreement when they're in a month-to-month agreement? I emailed and hand-delivered the addendum and asked them to sign it. The modifications are if they have a bounce house and it kills the grass, they will have to pay to get the grass back. I'm gonna help you, Joanne. Okay, hang on. The second is that there's a pool, and the pool guy told me that I need to modify the lease, so if a pool toy gets stuck in the pipes, the tenant must pay to have the small pool toy extra removed. Hang on, because you're asking me a specific question. You need to do a 30-day notice of change of terms of tenancy. The terms that you're changing, you may not need to change, okay? Let me ask you a question. There's something in your current rental agreement about the landscaping and that the tenant has to keep the grass green. They have to keep the landscaping green. I'm asking you a question. I'm not trying. If that's already in there and the tenant is required to maintain the landscaping, which keeping it green, and the bounce house kills the grass, it's already in your contract. You don't need to rewrite it, okay? Deep breath. Now, as far as the pool goes, there's probably something in there that says that if they damage the pool, they're responsible for the damage. Okay, so what I'm trying to tell you, Joanne, is this, okay? Pay attention because this goes for everybody. Listen to me. This is very important. There's a reason why your rental agreement is written with such broad terms, and it's just a general blanket statement, and it isn't specific. There's a reason why, okay? When you have that blanket of protection in the way that it's written in those legal terms, that they can't damage anything, and you rewrite it and say, you can't do this because of a bounce house. And if you have a bounce house there and the bounce house kills the grass and you're responsible for it. What if they park their car there and kill the grass? You didn't talk about that. So you didn't disclose that. So that doesn't count, right? Paying attention? Sometimes the more we try to be specific about our lease, what we're doing is taking that blanket of protection away. So you can't do both. You got to do one or the other. So if your addendum is more restrictive than your lease contract, then the addendum controls and not your lease. When it comes to restrictions, the restriction that restricts you the most is the one that controls you. Don't control yourself out of your lease contract. Let me give you an example. Had a tenant one day. You couldn't do, had an owner one day. You couldn't do anything in her house. No sticky back shelf paper, no wallpaper, nothing hung on the interior, nothing hung on the exterior. You could only use stainless steel cleaner on her stainless steel appliances. She had specific cleaner that you were supposed to use for the granite countertops. And she paid every 3 months to have the filter changed in the refrigerator so that you had fresh water. You want to talk about a landlord with a long list of addendums and different rules that you had to follow? Okay, now I have a new landlord and she has a different list of rules that you could follow. But it says things like you can't set hot items on the countertops. But you didn't say I couldn't set the hot cookie sheet on the floor. So I burned a hole in the vinyl because you didn't tell me I couldn't do that. When you start defining little problems, you're taking away that blanket of protection. Do not rewrite your rental contract based on a problem your tenant is creating. Instead, use what's already in your contract to your advantage. Example, I'm sorry, you having a bounce house is a modification to the property without written consent of the landlord, and the owner's insurance isn't going to cover it. It's not allowed. You cannot do it again. It is a material breach of your lease, and a reason for me to serve a 3-day curable breach of covenant notice. Also can serve a 3-day curable breach of covenant notice in the event that, hold on, let me go backwards. I got that you got it, Joanne, but I'm telling everybody else too, not just you, okay? We use this for training for everybody. So we got the bounce house, and that bounce house kills the grass. The other one is the pool, and I'm sure you have an addendum in there about damages to the pool. So just read the addendum you already have, and then ask yourself, does that blanket cover the problem? Because if it does, you probably don't want to change that. And why I'm telling you this is I had this problem happen, and I actually watched this owner go through a small claims case and lose badly, because there were more restrictions on her addendums than there were under the actual rule. I mean, she had a rule in there, and this is where I went, oh Lord. The rule was you can't have Christmas trees because you never bag them up and put them out in the trash properly. So because you guys don't know how to dispose of a Christmas tree, you can't have Christmas trees on the property. Does anybody have a bad taste in the back of their throat? Anybody? Why would we tell people they couldn't participate in their religion? Oh, I hope you guys all saw that coming. Discrimination against religious. Period. End of report. Watch yourself. Watch yourself. Do not sign up for an unnecessary lawsuit, okay? Just double check and make sure that the things are already in there. And then by all means, if they're already in there, just serve them a 3-day curable breach of covenant notice. They're in violation of their contract. I'm trying to think, what are the other things? Big things that are problems on our property: trampolines, swimming pools, bounce houses. In the eyes of the insurance company, and you guys write this down if you don't know the verbiage, it's called an attractive nuisance. Attractive nuisance is anything that attracts a potential nuisance to the property. like a swimming pool, attractive nuisance. A shed that's falling down, attractive nuisance. Trampoline, attractive nuisance. It attracts injuries. So your insurance company may tell you you can't have that on the property. It's an attractive nuisance. That's what they're talking about. So if you know your insurance company's not going to allow it because of a liability, why would you allow it? Oh, above ground pool in any size. Bad idea. Above ground pool in any size. Bad idea. Patty, what about those hard plastic pools that are like a 6-foot circumference? You know, as we got older, we filled them with ice and beer at parties. You know, they made great ice chests. Why can't we let them have those and sit in there with their toddlers? Because their phone rang. They left the toddler in the pool and they went in the house to go get the phone. They came back, toddler's face down. Whose fault is that? Can't hear you. Anybody know whose fault that is? The owner of the property. I don't allow above ground pools, ever. I don't allow trampolines, ever. And you shouldn't either. And believe it or not, I'm starting to not allow barbecues and smokers.
Okay, Patty. So you don't allow barbecue grills, and that was always from the beginning of your lease agreement, and the person brought it in respect of what you told them, no, it's not allowed. It's no place in the lease agreement, it never was. And yet you've asked this person over a period of years now to remove it, and they keep ignoring you and ignoring you. You told them about their plans, using your parking lot as their personal backyard. It's not a backyard, it's only a parking lot. How would you personally handle that? And again, it's Larso. So tell me, how would you handle that?
I would approach the tenant from you can't do this. You can't. That relationship there is busted. You need a mutual third party to step in, a new sheriff in town, hire a professional manager just to go crack the whip and tell them, hey, you can't do this. You got to remove this or we're going to have to start the legal process. You are in a material breach of your lease by agriculture on the premises. Okay, it's not allowed. That's a material breach of your lease contract. So that would cover them growing anything on the property, including an avocado pit in the windowsill. Okay, and so that was the one thing. What was the other thing they were doing?
The barbecue grill, this chain.
The barbecue grill. As long as you have it, so it's a 30-day notice to change of terms of tenancy that you're not allowing external grills on the premises. And smoking. And the reason I say smoking is because you guys got to remember, people smoke meat. Okay. So it's not just barbecue grills, it's also smokers. Okay, please remember that. Don't just say grills, you got to add smokers. Otherwise they'll go, it's not a grill, it's a smoker. It doesn't even have a fire in it. It takes little wood chips. It's a smoker. What was your question?
Having an attorney to serve that notice on them, would that be effective?
An attorney lets them know, either that or hire a property manager to serve the notice, or legal counsel to let them know, hey, and if you do it as a 30-day notice to change the terms of tenancy, it takes effect on day 31, and then you could serve a cure or quit in the event that you needed to go down that route.
Okay.
But I know you're in the devil's cauldron, and I don't want to sign up for a $60,000 or $80,000 E-word. I want to try to negotiate myself through the situation first and avoid that. Just so everybody knows, eviction in LA County are looking between 60 and 80 grand. No joke. Miriam will tell you, sometimes even more. I have a few LLCs that own my rentals. Hang on, I lost myself there. A tenant's dog bit the jogger in the street. I remember this, Val. They have renter's insurance. However, the plaintiff is also suing 3 of my LLCs. One is the owner, one is the manager, and one has nothing to do with this. My insurance says I need to hire an attorney to remove the unrelated LLC, even though it has nothing to do with this case, since it was not listed as additional insured, which there is no reason to have it listed. Pay attention, Val, I may ask questions later. I hope you have your pen ready. Ready? And if you're not ready, you can always call me later. Okay. At the hearing, when you approach and you introduce yourself as Val, and you introduce yourself as the owner of Maverick Properties LLC, and I'm just throwing a name out there. And then they say, and ABC Properties LLC, which is not a party in the action, you are going to tell the judge, Your Honor, I would like ABC LLC to be dismissed from this case. They are not a party in the action. Not a party in the action. And that's how you get them dismissed. Okay? Example. Yes, you can sue an LLC. It's more difficult for you to get a money judgment against them. But you absolutely can sue an LLC, a living trust, a family trust, a blah, 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 blah. Yes, you can. But dismiss your other LLC as it's not a party in the action. So let me give you guys an example. I work for ABC Property Management Company, okay? The tenant walks in and says, I'm gonna sue you, I'm gonna sue the owner of this property, and I'm gonna sue, hold on, I'm gonna sue you, I'm gonna sue the owner of the property, and I'm gonna sue the management company. So I get served with a lawsuit, small claims. It doesn't matter if it's small claims or anything else, this is how it goes, okay? I'm just giving you guys the whole thing. I know you don't want to go to court, Val, but you're gonna have to get your other LLC that's not a party in the action dismissed. So this is what I do when I show up as your property manager in court in small claims when they're suing you, me, and your management company. So this is what I say. Hi, my name is Patty Widget. I am an agent for the owner and I am not a party in the action. And I personally would like to be dismissed from this case. And the judge says, okay, you're dismissed. And then I take a step over to the left and I say, hi, I'm Patty. I'm with ABC Property Management Company, and our management company is not a party in this action, and we'd like to be dismissed. And then they say, fine, we're dismissing the property management company because this lawsuit is between the landlord and the tenant, no one else. So now I am standing there saying, hi, my name's Patty. I represent the landlord and I'd like to proceed on their behalf. So now I'm going to court to battle for you. But I took me out of it and I took the management company out of it. And now I'm going to do my best to get you out of it. Okay, so that's how that goes. You dismiss yourself as you are an agent for the, you are an employee for the agent. You are not a party in the action. The management company is not a party in the action. It's landlord and the tenant. That's it. Okay. So get yourself dismissed. If it's under your LLC, if they want to name you individually, I'd be asking an attorney about that, and I'd have them dismiss the other LLC because it's not a party in the action. People ask me all the time, what happens if I don't dismiss them? The money judgment goes against everybody.
Patty, I have a question, and I know you're not an attorney, so you might not be able to answer this, but is there a way for the landlord to be completely anonymous? I was told, or I've read that if the way you structure it by doing an LLC that owns something else, that owns, like, you know, it's just so that way it's like a complete anonymity for the landlord. Is that
No, you want me to be, and mind you, I worked in a law firm. I've watched them go after a landlord that did everything to hide, okay? let me say this. It's a matter of when, not if. Everything's public record. They will find you. You can run, but you can't hide. They will find you. They will come after you. I've watched them dig, dive deep, and rip things apart, depending on the extent of what you're being sued for. If they're coming after you for a fair housing violation, here's something you guys all need to know. Those of you that individually work at an apartment community, those of you that individually work at an apartment community can be held accountable for fair housing violations. They can come after your personal assets. What did you say, Patty? Take a fair housing course. I was doing one this month with Denise Cato. She's awesome. I want to say it's about $100, I'm guessing. You can run, but you can't hide. The reality is everything's traceable. You could have it in a family trust that's in an LLC, that's in an S Corp. And what they're going to do is they're going to start picking apart until they find where the money is. And they're just going to keep chasing the money.
I have a question, Patty.
Yeah.
Does it really make any sense to get your LLC out of Delaware instead of California? Do you gain any advantage because they have a tendency to keep you more anonymous over there?
I prefer a family trust over an LLC.
Elaborate.
If I have an LLC, I'm automatically giving $800 every year to the state of California. Why? Just because I have an LLC. How is that LLC protecting me? Because in LA County, if I hold title under an LLC, they look at me as a business and I'm susceptible to statewide rent control. Even in a single family residence, just because I'm in LA County? No. I'd rather have mine in a family trust or a living trust so that I'm not giving $800 to the state right away. And I don't think that it offers me that much more protections. I like a trust because if somebody tries to sue me, they can't sue for what's in my trust account because that money doesn't belong to me. It belongs to my family. Makes it a little bit more difficult. Nope, you're going to have to, a family trust versus a living trust. Nope, you're going to have to ask an attorney. I am right here on my pay grade, you guys. I know that a living trust can be revocable or irrevocable, meaning it can be changed or it can't be changed. There's a lot of moving parts and a whole lot of legal stuff I don't know nothing about, so we're not even going to pretend. Okay?
What I was faced with, Patty, when I went to court, just so everybody on the call would hear, they said I would be able to represent myself if it was not in a partnership or another entity. If it's only in your name, you could represent yourself in any type of court case. But
well, you can represent yourself as an LLC. You absolutely cannot represent yourself as a corporation.
well, that's not what the judge said. The judge literally said that. She says, are you representing yourself as an individual? I said, no. Is it a company? I said, yes. She said, you can't.
You can't
But
represent a company unless you're an attorney.
right, that's what she said. I was just
Exactly.
because-
So you could have represented yourself as an individual, but you can't represent the LLC.
well, see, that's what I'm confused on. So even if you were in
Even
a,
if you're a sole proprietor, here, let me help you. If you have an LLC in LA County and you're exempt from everything, you're still governed by state law, right?
Mhm.
In LA County, they say LLC works as a corporation, so you're subject to state law.
But what about if you're representing yourself in terms of the living trust, like you said, and I don't want to ask you anything above your pay grade, But if you're representing yourself and you
If you're
are,
a trustee
Huh?
of the trust, if you're a trustee of the trust or currently the trustor, you have
Yes.
all the power.
okay, so you can represent yourself.
Absolutely. You cannot represent yourself as a corporation at all, even in small claims.
But aren't you more exposed when it comes to lawsuits by not being in a company? Aren't you exposed? Because if you have a partnership, or if you have LLC, let's say that you own 1/3 of the LLC, you have a 33 1/3% ownership. Aren't you
And
somewhat?
now that you have multiple partners, this is a business, not an individual, so you're subject to California statewide rent control.
Hmm.
And that's how they look at that. And it is currently being heavily litigated and argued. But I'm letting you know so that you don't go stick your foot in the pond for no reason. You know, that's why I'm here, you guys. They have this saying, it's kind of, I shouldn't say it, but a lot of people say it. FAFO. If you fart around, you're gonna find out, right? I've done all of that. Don't find out. Listen to me so you can avoid the problems. I've played those games. They're not fun. All right, let's see. I got get a good asset protection attorney. Absolutely. Asset protection, real estate attorney that's dealing with real estate, not so much eviction. So Patty, being that we have to supply a copy of the credit report if we deny them based on credit, then we can no longer say that the report doesn't provide that, right? Because it's on the report. Hold on. If we deny them based on information obtained in their credit report. Julia, I think you're overthinking it. Okay, let me try a different way, okay? My criteria says no evictions, you must have a 650 FICO score or higher, and I'm just rambling some stuff off, and 1 year employment, okay? So that's my criteria. So I set up my criteria, that's what my criteria says, and now I run their credit and they have a 649 FICO score. I'm going to deny them based on information obtained in their credit report. I'm not going to go into specifics saying you don't meet based on information obtained in the credit report, and then you're sending them a copy of the report. If the same information that you pulled out of that report is why you're denying them, then you didn't do anything wrong. Okay, don't overthink it.
Hey Patty, quick
Yes.
question on that. What about like if they say the credit report and then everybody who's over 18 on the rent must be on the lease. And then what about like sometimes the landlords will say, well, they want two times the rent. They got to make at least 2 times the rent. And they send your bank statements and stuff like that, and they're 49, it seems like every month they're $49 in the hole or what have you. I just, because of the way everything is, and we do many rentals, we just got to be careful. We've done a lot of stuff that you have said, and it works out good, just to be correct in a way, the way we see things. But something like that, do we ask them, hey, do you have any money left over? I mean, what do we do on that?
Well, one of the ways I do it is you got to make 2.5 times amount of the monthly rent.
Correct.
Okay. If they make 1,000, if the rent's $1,000 a month, they got to have a job that makes $3,000 a month, right? Right?
Correct.
If they don't make $3,000 a month, they're not income qualified.
Income qualified. Okay, you're awesome. That's all. Don't overthink it. I know, but I'm looking
I
for
know,
words.
and sometimes I have to go all the way down the rabbit hole to give you the word you want. So that's just teamwork of us working with each other's brains. Okay, I'm the weirdo.
Okay, all right. I appreciate you. Thank you.
Patty,
No worries. They're not income qualified.
are you talking about the net income or gross income? Because someone make thousands of dollars, but
And
we
it's
still-
gross what you actually get to take home, right? I'm kidding.
No, really.
I
Well,
know.
would you base it on the net income 3
You
times?
have to base it on net income,
Right, thank you.
not on their take-home pay, which is garbage, but you have to.
Patty,
Yeah,
I have a question. Today I got a call and it was a random person and they said, "Do you have a paper application?" And I said, "Yeah, I do. Are you having issues applying online?" And they said, "Yes, it's not allowing me to move forward because it's asking for landlord information, and I don't have landlord information because I'm homeless." And that's part of our criteria. On our list of criteria, it says that we do need landlord information and a good recommendation from the previous landlord. And so I said, "Well, that's in our criteria that you need to have that." And she said, "Well, that's discrimination." What is your opinion on that?
hi. I'm 19 years old. I'm moving out of my parents' house for the first time. I got a job already, so I have income and I'm going to school and I want to rent your unit. Do I qualify?
No.
See the problem?
Yeah, I see the problem.
No
She's
rent.
right. It's discriminatory.
It is?
In a way, it is, absolutely. I mean, if I live in if you're saying that I have to have good landlord references and I am 18 years old and moving out on my own, my previous landlord is my mother. Just saying. You think she ain't gonna give me a good reference? You get where I'm coming from? You're gonna have to be cautious what you're doing. I'm just giving you another angle to think about. Am I gonna have to go down the rabbit hole and find out if that's discriminatory? They're gonna find a way to make it discriminatory. You better believe it. Especially in California against homelessness. Good luck.
So then we have to take that off of our criteria list.
Hold on, let me dive into Widget's brain, okay? Hang on. Sometimes it takes a while. You can't make it a requirement, because what if they're a minor going out on their own for the first time? You would be discriminating against them going out on their own for the first time. So are you discriminating because they live in a tent? Yeah, because I don't live in a tent and I got to pay rent and utilities. So does everybody else. But because they're not living that way, can we hold them? We can't. I'm going to have to ask my good friend over at Fair Housing, but I think we may have found some kind of a loophole we need to watch out for, you guys. Because my brain is telling me, watch yourself, watch yourself, watch yourself as you're dancing around the fence on this one. I think that we're not going to be able to discriminate against homelessness is a protected class in the state of California. They just made that. Ding. So no, you can't discriminate against them being homeless.
But what I don't understand, Patty, you're not really discriminating. They don't suit your criteria. So how would that be discriminating if they're not fitting your criteria? You're saying that you have to have been working for 2 years, you have to have X number of dollars for income, you have to have a credit score, etc. How is that discriminating? I'm lost.
Where you got them is they have to have, you're putting homelessness with a job. Let me tell you something, okay?
Okay.
And I got to be careful what I say because this is real, okay? One of my best friends and somebody I stay in is head of human resources for, I'm going to use a different company, okay? But I want to use something similar. So Best Buy, okay? We're just going to go with Best Buy. She's head of human resources for Best Buy locally, okay? So she runs the distribution center, distributes to the other stores, also does private sales, but she's the head of human resources. Do you know that she has about 12 people, give or take, that are homeless that work for her? They make over $20 an hour. What? They're homeless. They're homeless by choice. If you go talk to them and ask them, they're like, I'm not giving $3,000 to somebody every month and getting nothing for it but a roof over my head. I could take that $3,000 for 1 month, go to Bass Pro Shop, buy all the top of the line equipment to go camping in, go camping somewhere, go to the gym every morning and take a shower, eat out all the time. I have solar panels on the top of my sun tent that charges my cell phone. Some of these people are choosing homelessness as a lifestyle. Just so you know, we have a whole generation of minimalists that like the van lifestyle, that are living in their cars while they're working careers, and she asked some of them, why do you do that? One of them said, oh, I live in a camper and I stay at all the beach communities, 14 days at Newport, 14 days at Bolsa Chica, 14 days at Dockweiler, 14 days. They're living a good life. Homelessness is a protected class in the state of California that happened January 1st, 2019. It was before COVID when homelessness became a protected class, or it happened the very same year. Who would know? April might know, and Arlene just got on. She was late today. She has questions for us today.
Here's a question for you.
Joanne, hold on, let me answer Joanne's question really quick. Sorry, Miriam. Is that combined income of all parties or separately? It depends on how you wrote your application status. I hope that makes sense to you. It all depends on how you wrote what your requirement is. And if they're a married couple, you treat them as one. They're a protected class in the state of California.
Patty, real quick, concerning on that. So let's say I have something like that. Just there's someone on the line that they asked me this question. I remember, and we talked before extensively on it. TIN numbers. So you have 3 people, 2 Social Security, and let's just say 2 with TIN to make the rent. And I remember you were saying something about the TIN, and I remember what it is, but I'd rather have it from the lady's mouth. I don't want to say horse because that's different. The lady, beautiful lady.
It's okay, I'll be the horse, so it's okay.
Yeah. Go ahead, the TIN.
I'm just a miniature horse, like a pony.
Okay, little pony. Could you explain the TIN? I remember you saying that.
A TIN is a taxpayer identification number. Example, we are bringing in immigrants to this country. We are taking in people that are seeking asylum, whatever, okay? I don't want to get into the political part of that. That's not where I was headed.
Bye.
What I'm trying to say is that we're documenting them, okay? They're not undocumented, they're documented. They get IDs, they get driver's licenses, they get social security cards that say for tax purposes only. For tax purposes only is a TIN number, and it's so they can work and pay federal income tax. But it doesn't mean we can garnish their wages or use that to run as a credit score. Okay, keep that in mind. That's what a TIN number, it's a tax identification number.
So if it all went south, they're pretty much ollie oxen free, and the other ones will have to pay.
Well, look at it this way. It's debt that's uncollectible.
Yeah, okay, that was what it was. That was a big key, and I know she heard that. So, all right, thank you.
Uncollectible debt. It doesn't mean that you can't rent to them, because you can't discriminate against them for source of origin, source of income, blah, 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 blah. So you can't say, I'm not going to rent to you because you're not a legal immigrant in this country. It doesn't work that way. They have a TIN number, they can legally work here, but it doesn't mean we can collect from them. Okay, so just one of those things that's nice to know. So Patty, what are you saying? I'm saying, would I rent to those people? Absolutely, but I'm going to have a 0 tolerance policy on late rent, meaning on the 1st of the month, I'm ready to serve my 3-day notice on the 2nd. I'm not waiting until the 5th to see if they pay before their late fee applies before I serve a notice. I'm serving it on the 1st day it's delinquent every month because I have a 0 tolerance policy on late rents. I am very strict. When I move people in, I let them know, I'm sorry, I just wanted to tell you up front, this owner has a 0 tolerance policy on late rents. So late rents is not something that's gonna be acceptable here, just so you're aware.
All right.
Hey,
thank you.
Patty, on a person with a TIN number, can you put a lien on their wages?
Can you put a lien on their wages? It's for tax purposes only.
But they are working and they're paying taxes. If you know where they work, can you put a, no?
You can attempt to, but I don't know that you're gonna be successful at it. I don't want you to take the risk. Make sense? I
Okay,
want you to be quick to evict for non-payment and not expose yourself to trying to work with them because, you know, we're trying to make it work. Be quick to drop the hammer on because the debt is uncollectible. Can't you also change the agreement to 3 days versus 5 days, even though 5-day is on the written contract? Val, I believe what you're speaking of is the grace period, and you don't even have to have one. I don't. Rent's due on the 1st. Late fee applies on the 2nd or the first delinquent day of the month. I don't have a grace period. So
in
it's
that,
not a requirement. Go ahead, Miriam.
or in that instance, if the rent is due like this month, it was due on the 1st, it's on a Friday, but you don't receive it until Monday because Saturday was the 2nd and Sunday was the 3rd. How do you count that in terms of being late? Because it was obviously due on the 1st, but they didn't even postmark or buy the check, the money order, until the 2nd. How do you handle that?
Well, the rent was due on the 1st and it was a business day and the bank was open.
Mhm.
They didn't pay it on the 1st.
Okay.
My late fee applies once the rent is delinquent. It's delinquent on the 2nd.
See, I didn't think that we can continue to charge late fees. I thought there was something that passes that we can no longer apply late
Here's
fees.
what I'm gonna tell you, and just listen to me. And Miriam, you would know this more than anybody else because you've been in court quite a few times in the last 18 months.
Okay.
If your tenant pays you a late fee, accept it. Take
Okay.
it. Put it
Okay.
on your books. Take in that money, okay?
Okay.
Don't serve a notice or pursue trying to evict because they're not paying the late fee. You're losing that battle.
Okay.
If your tenant's paying it, if you serve a notice and then they pay it to you, collect it, put it in your arsenal. In the event you have to go to trial, your legal counsel is going to tell you to provide a ledger that doesn't have any late fees on it. Listen to your legal counsel. They're telling you to do that for a reason. We're going to lose them. We haven't lost them yet. I will tell you, if you're in LA County, don't press the issue. Other counties, go for it. Serve them the notice, see what happens. If they pay you, they pay you. But it's not something your legal counsel wants to see on your ledger right now because legal fees are being heavily litigated. Why, Patty? I'll tell you why. It's because of people like me. Sorry. I have a rent. It's $3,000. My late fee's 10%. How much is my late fee? $300, right? It's a deterrent, Your Honor. I don't want them to pay the rent late, so I'm going to gouge them. If my bank doesn't get their mortgage on time, they charge me a $35 late fee. Now, am I making secret profit? Am I price gouging? No, Your Honor. It's a deterrent so they don't pay the rent late until you collect it. We don't want to be involved in this argument. It's bigger than our own britches, okay? So that's why they're telling you remove your late fees, don't put them on your ledgers. They just don't want to expose you to the argument and that unnecessary litigation. That's the why. Hope that makes sense.
Yeah, the credit reports, you said that, whether they ask for it or not, do we have to provide them a copy? That's one question.
You're
And it's not
going to have to now, you're gonna have to
Automatically.
provide them a copy within 7 to 10 days.
No, because what I was told, if you're not in the credit reporting agency, you don't have the right to give it to them. You give the prospective tenant, you give them the phone number and the ID number, and you call the credit reporting company, and they are supposed to unveil and give them a copy, but not the landlord.
Correct. You don't have the qualifications
Right.
in order to discuss with them what's on their credit report. So you should never be saying, but it says on your credit report, you've been evicted 7 times. That's bad business. You are not certified to be talking to them about what's on their credit report. Okay? So we don't discuss with the tenant what we found on there. We just tell them if they're denied, they're going to get a copy. But now we have to provide them a copy within 7 to 10 days of the actual credit report. Yeah, we have to do that now. Within 7 to 10 days, we got to give them a copy of the report.
7 to 10 days.
Hey Patty, this is Lorena again. Circling back to my initial question. So
I
am I
like
supposed
circles.
am I supposed to take off that from the criteria, the landlord verification? Are we supposed to take that off? Because I got it from the initial criteria that you sent us from Widget's Way.
Well, you can leave that you have landlord verification on there. But because you can still ask to talk to previous landlords, but if they say that they're homeless and they don't have a previous landlord, I have other questions, okay? Not trying to be a jerk, but just asking questions, okay? Like Lorena, if they're homeless right now, how long have they been homeless? Have they been homeless their whole life? If the answer is no, then they have landlord verification, right? I'm asking
Right.
you, not telling you. Do you see what I'm saying? I get that you're homeless right now. And I understand that right now you don't have a landlord, but did you have a landlord previous to that we could check with?
Can I ask, how did you become homeless?
I wouldn't, and I'll tell you why I wouldn't ask them. Homelessness is a protected class in the state of California. So it's kind of like when you have somebody that says that they have a service animal and you ask them, oh, what service does it provide? And that's all you can ask. That's all you can say. So if they say, oh, the dog gets my shoes for me, you're going to go, oh, that's great. They provide a service. If the tenant says, my dog doesn't have to provide a service. Yes, it does. You just said it was a service animal. What service does it provide? Your tenant's using the wrong verbiage. They're probably meaning to say emotional support animal, but they use service animal. And now you're in a hiccup because you asked a question. You can't ask them, what do they do for you? No, what service do they provide? Oh, they get my shoes. Question asked, question answered. They alert me that the doorbell's ringing. Question asked, question answered. That's really cool. Don't ask the question. It's not worth the risk.
So is there anybody on this call that would literally show their apartment to a prospective tenant with his shopping basket that just left the park that's homeless?
I'm sorry. I require that you make 3 times the annual or 3 times the monthly rent. Do you currently have a job?
Okay.
See how that works?
Patty, going back to that service animal, well, I don't know how they're getting them passed through, but sometimes they're just bigger dogs.
Hey, I just wanted to throw something at you so that it made those fireworks go off in your head. So you went, whoa, 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 I got to be careful what I say right now.
Hey, Patty, with the dogs and the service animals, we require everybody to have renter's insurance. It's on our contract. If we
Wait a minute, you require everyone to have renter's insurance.
correct.
Everyone treated the same. Keep going.
Okay, so I know they have, it doesn't matter. The dog is the dog. So do we tell them actually about how about the dog? What if it bites somebody? Hypothetically, They're in a complex. Two of them have dogs. They're fine, but we're trying to protect ourselves because if that dog bites the mailman, bites whoever, we tell them to tell the renter's insurance company also that they have a dog on site with them. Are we still liable?
You're always liable. You're the landlord.
Understood, but
If that
like a
dog bites
catch-22.
someone, it's a 3-day quit. You're out of here because you just put the landlord in a huge liability
Oh,
situation.
love you. Got it.
3-day quit.
So, okay, does that mean they have to get rid of the dog then?
3 days. You have 3 days. Your dog assaulted your wheelchair just bit someone.
Oh, got it.
You have
Good to
3
know.
days to get out.
Okay,
Patty,
good to know.
question, please.
Yep. Deep
Uh,
breath, you guys. Deep breath. Different set of facts when you're dealing with a bite.
I've seen a landlord with a pet agreement that states your dog must be neutered. Is that legal? And
Yes.
you're not, yeah, that's
Yes.
legal?
Yes.
You can force it?
Do you want to know why?
Go ahead.
When it comes to pets, there are no rules. You can say, I only want purple papered poodles at my property. But if it's an emotional support animal, my rule goes out the window because it's now a wheelchair and assists somebody that's disabled. But when it comes to pets, you can make whatever rules you want to. There's no laws governing that. There may be a law within the municipality putting restrictions on how many animals they allow per household. You have to
Okay.
follow that law. You can't break the law. So if they say you can have 2 dogs and 1 cat per household and you have 15 cats, you're breaking the law.
In the same agreement, he has, you cannot have someone feed your dog while you are at work.
Okay, hold on a minute. Hold on. I'm going to leave for a week and I'm going to take a cruise.
No, just
Does
on
that dog have to starve to death while I'm on vacation?
Or then he can become more than a visitor. He becomes a tenant.
Exactly. What do you mean you can't have somebody come feed your dog? You have an unauthorized occupant. That's not an occupant. That's my dog person. Okay, it's your dog person. No, they can have a paper boy. They can hire employees. They can hire a house sitter to come sit at their house while they're on vacation.
And do they have to pay extra for that as a tenant occupant? No.
No.
Yeah, thank you, Pat.
I mean, look at it this way. What if you were going to go see your grandkids? And I'm just throwing something out there, and you're going to go see your grandkids for 2 weeks this summer. You're going to have somebody stay at your house for you and water your plants and water your pets and walk your animals and answer your business calls. I don't know. It's our right as humans to be able to do that.
You're so wonderful for clarifying all this.
I mean, look at it this way, and this is the easiest way that I could explain things for you guys, okay? When you're thinking about something that's going on, just ask yourself, what would I do if that were me? How would I want to be treated if I were a tenant? What do you mean I can't have somebody come over and feed my dog while I'm at work? What? No, I absolutely can do that. You want that to happen. You don't want my dog stuck in my property all day while I'm at work. You want somebody to come over and feed them and walk them. Okay? You want that.
Is that against fair housing, or what would you classify it under?
That's an employee for the tenant. No different if they hire a caregiver, a paper boy. You following along? Somebody to wash their car. It's their employee. Has nothing to do with you. So you're not gonna discuss the rental contract with them. You're not gonna tell them that they're breaking the rules of the community because they're not your tenant. They're an employee of your tenant. You're gonna go talk to your tenant about whatever problems are going on there because of them. Okay?
So let me ask you this about the insurance. It's in their contract. They've all signed that they agreed to get the renter's insurance. They haven't. How much notice should I give them to correct that situation? How much time should I give a tenant to correct the void of not having their insurance?
Well, I would, first of all, remind them in writing that that you are not in receipt of their
Okay.
policy.
Okay.
And that you're gonna need this within the next 30 days. That's a
Okay.
reasonable amount of time. I mean, think of it this way, if your insurance company was bugging you to do something, 30 days is a reasonable amount of time. And look at it in a different perspective. If you were to give them a notice of change of terms, you'd have to wait 30 days anyway. So just follow that guideline. It seems to be reasonable with the courts in your area.
Okay.
So I'd send them a letter reminding them that I don't have I'm trying to think a declaration page. There we go. I was trying to think of the word for their renter's insurance policy, and you need to have that within the next 30 days. And then if they don't provide that to you, I would serve them with a cure or quit notice for that reason. Okay? And in Larso, it has
Patty?
to be on the original
Patty?
contract. It's not something you can add in without their signature and approval.
It was in the original contract. But with that being said, if it's 3 different individuals that are staying there and they're not married or whatever, do they each have to have the insurance, or they get one policy and all of them are on it?
I would think it would work well if they had individual policies or one policy and all of them named on it. I don't think it would matter either direction. Let me ask you a question. Are these roommates on separate rental agreements?
2 of them are, and one is there illegally.
If they're roommates on separate agreements, then they must provide separate policies.
Okay, thank you.
That's the best way I could describe that.
Okay.
A tenant is complaining about termites in the kitchen. Bummer. Just had an exterminator give me a bid. He said $1,200 to treat the kitchen cabinets and $1,200 to treat the subterranean in the front porch area. I will clearly do the kitchen, but the subs are in a completely different area. I do not expect to sell. I don't really believe they're get rid of them. I'm just wondering. Usually you get the subterranean termites where wood hits dirt. Okay. So if you have a wood front porch or a wood walkway, usually you get subterranean termites in that wood area where the wood hits the dirt. It's up to you, Val. If you're not gonna fix it right away, and this is me talking to you, I'd go check it or have it checked every 5 years to make sure that they're not deteriorating it so badly that your tenant's gonna fall through the porch. You know what I mean? We don't want that. We don't want that. You guys know I fell through a house once, right? Woo! Thank God there was carpet. I really did. It
Hi,
up to
Patty.
my knee in a
I have a
mobile.
question.
Yeah.
Sorry. I have a
You're-
question regarding the renter's insurance. I was talking to someone in Section 8 today and I mentioned something about renter's insurance. They said that the Section 8 tenants are not required to have renter's insurance.
Who told you that?
It was a representative from HIP. It was a Zoom meeting this right before your meeting started. That's why I was a little bit late. But yeah, she was saying I asked about renter's insurance. I said how, because I gave him
Okay.
the amendment and he still has not provided me with the renter's insurance. He said he's not gonna get one. So how would I get him to get the renter's insurance when Section 8 is telling me that they're not required to do it?
Okay. And the reason I'm going, huh, is let me ask you a question. You signed the HEP contract, correct?
Yes,
And it's their contract.
yes,
They didn't want to sign yours, did they?
no.
And now you know why. HEP contract doesn't say that insurance is a requirement.
Hmm.
Next question.
Then how do we,
30-day notice to change the terms of tenancy. Can't do it until the term's over.
but the tenant would have to agree or the tenant does
What
not have
city
to
is it in?
agree? It's in Downey, it's LA County.
Unincorporated?
Yes.
Let me ask a different question. DCBA?
No,
Is it
what is that?
registered with the DCBA? No, because
No, no,
Downey's incorporated LA County.
okay.
Hold on. I'm going through the law in my head. That's what
So
you see
Downey is
happening.
incorporated?
Downey is an incorporated. This property is
Incorporated.
not registered with the Department of Business and Consumer Affairs, correct?
No, yes, no, it's not.
Okay, so now I know what the rules are. Give me a minute and let me go back through in my brain, okay?
Thank you.
HAP contract doesn't have any terminology in regards to renter's insurance. You're gonna have to wait until the 1-year term's over and then do a 30-day notice to change the terms of tenancy in regards to the insurance and hope that they don't change the law by then.
So the 30, wait till the end of the year term, that's when they come and do a reinspection, they do a reevaluation of the tenant, right? Not necessarily when I do an increase on
Oh,
the
no, they're
rent.
gonna make sure that the property's still up to standards. You are aware that sometimes Section 8 makes you clean the carpets before they'll approve it to be recertified again?
The owner cleaned the carpet? I thought it was the tenant's
Uh-huh.
responsibility.
Yeah, no, Section 8, it makes that a requirement. Sometimes they make the owner go clean the tenant's filth.
That wasn't true for me. Ever.
I'm telling you out loud so you don't get shocked if it happens to you.
Actually, I have a tenant like, I think it's Miriam, that she's reporting me to health services and everything, but it's her mess. She's the one that has roaches. When I rented the property, I didn't have any roaches in the property. Now she doesn't clean, she has
So
roaches,
here's
and
what
she's reporting me the same, and she's having them come and inspect after Section 8, inspect the property a few months before they came, and they saw, and it was perfect when Section 8 came. But now the health department is coming and they see all this. And yeah, I had to replace a carpet because it was really filthy. And she didn't clean it. So yes.
there is a health and safety code violation for cleanliness and failing to comply with the exterminator. So in the event that you need to have an exterminator go there and she has to prep her unit for the exterminator and she does not comply, it's a reason for you to evict her.
See, I didn't know that because this happened, I think a year and a half, it was a year and a half ago. And the exterminator came, they treated the unit, they came, because it was 3 months. So in the 3 months, they came twice again and they retreated the unit. But I went and I saw her cabinet. She had to clean everything. There were still items inside the cabinet. She didn't take everything out. There was still, she didn't.
That's when you get a good relationship with your exterminator and you have him put in writing that he can't facilitate fumigating the unit because the tenant didn't comply with facilitating the unit to his standards. Then you serve her a notice to either comply with the exterminator or move out.
I wish I knew this before. I'm glad
It's okay, that's why
in
I'm
your
here.
team. I'm glad
I'm
in
here
your
to,
team. No.
I'm here to help you guys.
Thank you.
No problem. Welcome aboard.
Here's another scenario, Patty. There was a tenant. She was Section 8 from the beginning. She got another job. She's making too much money. They removed her from Section 8. Now, I know you told me before I don't have to change. I can't change the agreement, the lease agreement that was coupled with the HAP agreement. So I want her to pay her insurance. So I can give her a 30-day notice, also letting her know that her insurance, but she's played the game many times before. She'll get the insurance, and see that I get a copy of it, and then she cancels. This happened over and over. So
So make sure that you're listed as additional insured or interested party is the key word if they won't list you as additional insured. And they will send you a cancellation letter every time that policy is going to be canceled for non-payment. And every time I get that letter from one of my tenants, which happens every flippin' month, I serve them with a 3-day cure or quit to show me a copy that their insurance has been paid.
okay,
So some of us do that with a 3-day pay or quit for the rent. Some of us do that with a 3-day cure or quit for the insurance.
all righty. Thank you.
No problem. All right, does anybody have anything else? We're 20 minutes over and I have missions I need to accomplish today. Hopefully I'll see you guys tomorrow at AGLA in Koreatown. I think I'm there at 11. We're talking about how to prepare yourself for court. We're going to talk about how to avoid court, and they're feeding us for free. So I hope to see you guys there tomorrow.
Thank you,
Thank you for the
Patty.
extra time.
Thank you,
Thank you, Patty.
everybody.
Thank you,
Always.
Patty. Thank you so much.
Thank you,
Bye-bye.
everybody. Everybody have a great day.
You
Bye.
as well.
Bye-bye.
Bye-bye.
Bye.